episode 12 of Coffee with Casey. Today, I'm very excited to have Matt Pomy back for a part 2 of our probate discussion. Before we get started, I just wanted to run through the housekeeping items as a reminder for everyone, and in case we have any new attendees out there today. Today's webinar will be an interactive session, so if you have any questions during the presentation, please feel free to type those questions into the chat feature and we will answer them as best we can live on the air. Today's webinar is also being recorded, and a link to the recording will be sent to you following the webinar. Also, at the conclusion of today's webinar, a brief survey will appear on the screen. We appreciate any feedback that you have on today's session, and if you have any suggested topics for future webinars, we would also like to hear those. Today, we plan to end by 9 a.m. my time, 10 a.m. Matt's time. So with that, we'll go ahead and get started. Welcome back, Matt. Thanks again for coming on to being part 2. And if you could just introduce yourself to everyone out there today.
Yeah,
oh,
you.
There we go.
Pomy. I've been with, I'm sorry. Oh, yeah. My name is Matthew for about a little over 7 years now. I've been doing the probate work for our office nationally for about 5 of those years. You know, just primarily working with our legal collections department, and then as well with working any sort of contested probate issues, rejected claims, things like that.
Awesome. Thank you, Matt. And today's key topics, we're going to discuss what to do when a borrower passes away and collateral remains in possession of heirs or occupants, and balancing recovery rights with probate and compliance issues while also being understanding to the heirs. So with that, Matt, I'll kick it over to you. And also, everyone, please remember, you can put your questions in the chat. Thank you. Go ahead, Matt.
Absolutely, thank you. So today I wanted to focus on sort of talking through the points in which you're most likely to want to get involved in probate, some of the entry points where you have you know, an opportunity to get involved in probate issues. So when you want to engage outside counsel or I guess in-house counsel, if that's an option on your end, and you know, emphasizing that early engagement is gonna be your best defense in you know, missing deadlines or potentially losing track of collateral or anything like that. So going through the different times in which you want to key in and get involved when there's a deceased obligation or a decedent with an obligation to your institution. So basically.
Sorry.
Yeah, so, oh, no problem. So yeah, so we can go to the next slide. We're going to start with when the estate when you get notification that there may be an estate open. So that's when you get notification of a date of death, whether you search for your own or you send that out to a vendor to do any kinds of scrubs for obituaries or Social Security notifications. We also offer scrubs for entire portfolios, and we basically just look to see if there's been any report of a death for an obligor. Whenever you get those kinds of notifications, you want to flag the file and start the process for identifying probate or identifying responsible parties, because you likely have collateral out there. I guess that's really the main assumption that I have with everyone listening here, is that you have a deceased account, and in that account is secured by collateral. So that's really the main thing we're focusing on today. So you want to identify the parties as early as you can, especially if you don't have any indication that there's an estate. So the next thing, sometimes you may be content to allow your UCC1 filing or other secured filing to protect your interest when there's collateral out there. But if you get notice that the heirs or family are still using or occupying the collateral, that's also a point where you may want to key in and get involved with the heirs or the estate to make sure that your interests are protected, because whenever there's anybody using collateral that's depreciating its value, and it's putting the risk of loss on you, which is not where we prefer it to be as your attorneys. So whenever you have a notice that you have your collateral being occupied, you want to reach out to contact the family or the tenants or the heirs, or potentially a co-borrower or something like that, whoever's using the property, and you want to seek a resolution with them or a state counsel before you start seeking self-help processes out there. If that doesn't work, it's time to bring in us or your chosen counsel for a particular replevant action, and you want to go get that collateral so you essentially stop losing money there. Importantly, you want to document all your communication with these heirs or the estate, just to keep track of everything that's going on and make sure everyone's on the same page, both in your organization and with the estate and the heirs. When those expectations out of whack, is when a lot of problems arise.
Matt, question for you.
Third biggest entry point, sure.
Would you recommend early engagement of counsel after that initial notification of receipt of a date of death or an obituary?
Absolutely. I recommend all of our clients get us the file as soon as possible. Most of them will try to keep a deceased account for a little bit to do some collection activity on there, but in my opinion, that's probably going to cause you more problems in the long run than it's going to solve. I think it's easier to get it to your trusted professionals who know the ins and outs of the probate process. We're going to be able to get that claim filed timely and step you through that process. So yeah, I would get the attorneys involved as early as possible, but obviously that's a business decision. There's a few other points where if you're comfortable waiting, which I wouldn't necessarily recommend, but if you are waiting, there are a couple different places where you can jump in and get involved. But if you're already involved and something backs up, then you're in a better position than you would be if you were just getting into the case at that point. Yeah. Yeah, I mean, whenever you get a notice that there's actually an estate opened, that's notice of letters being granted to an individual to be able to step into the shoes of that deceased party. That's a big point where it's time to start talking to that person. It's time to start trying to see if you can't resolve the obligation once and for all, and now that you have someone to actually contact. So that's we're tracking probate filings, and most of the time the estates will advertise that someone has been appointed, and that's sort of the time when everything with the estate's going to start getting rolling. So that's when you want to file the claim to protect your interests for any deficiency balances. I recommend filing a claim across the board, no matter what. If there's an estate and we're timely, we're filing a claim. Once that claim's filed, you're going to put the estate on notice for what they need to do and what they need to pay, and then it's time to start coordinating with them for either recovering the collateral or working for an assumption or something along those lines.
I'm sure this is probably state specific, Matt, but as far as like timelines for filing claims, are there any important deadlines that people need to be aware of?
Absolutely. So I'll highlight a few. I would think a good assumption may be that we may have a lot of people here. So I would say I would highlight their claim period, because also it's one of the most strict. You have in Ohio 6 months from the date of death to file a claim. Now, it doesn't matter if an estate opened or anything like that. That clock starts as of the date of death. And you have to present that claim to an appointed fiduciary. So an estate has to be opened and a fiduciary has to be appointed within that 6 months, or that claim's not going to be timely. PA is 1 year from the date of death. That's also, pretty common. In general, that's kind of our benchmark. When we're dealing with estates, generally, we look at that 1 year from the date of death as a really important date to do something or not. And that's going to be true secured or not. So obviously, with the security in place on the obligation, the lien will still be in place if you don't file a claim, but you're essentially waiving any interest that you have in that deficiency balance. Another good point to get involved. This is probably the last point where I would say is a kind of a big point where you can start kind of mucking around in the state, is when you start getting notification that there's an issue with insurance or there's an issue with preserving that collateral while it's out there. So whenever there's collateral being used, you're going to want to verify that insurance is in place. And if you can't get some sort of satisfactory proof of that, it's time to go secure that collateral. So unmaintained or uninsured collateral is not something that I'm interested in having out there. If there's an estate, driving around, grandma's car, or if there's a guarantor who passed away and the walk-in freezer of a restaurant is your secured collateral, you want to make sure that that you're protected while you sort of transition that obligation to either the next person or getting a payoff. Oh, so I guess it's not the last one. So I guess related to this one, to the insurance issue is title issues. Anytime your right to the property underlying it is going to be in question, is going to be something that you're going to really want to engage counsel and review those issues with, particularly when it comes to state issued titles. I know Ohio, Florida, and PA, and I'm sure others have exemptions that allow certain vehicles or other secured assets that may be able to transfer outside of probate. It's important to keep track of those transfers so that you know who actually owns the vehicle before doing any sort of repossession activity or anything like that, because the collateral may have changed hands since the death by operation of law, and that may change the calculus on your end. Obviously, the lien will still be in place, but who owns the collateral, who's controlling it, who actually has those interests, is going to be key moving forward in any sort of legal contest.
Okay. We did have another question come in, Matt. I think this might be in relation to what you mentioned about Ohio and the 6 months that from the date of death to file a claim. Is there ever an instance where the creditor will have to open the estate to get that claim filed?
Absolutely, I'm doing one right now, actually. So yeah, when you have indication that there is not going to be an estate, but you have valuable collateral out there, and you think there's other valuable assets in the name of the decedent, it becomes essentially the onus shifts to the creditor to enforce their own rights. So if you're not going to get an estate opened and a fiduciary appointed within that 6 months, it's time to start doing a cost-benefit analysis of actually going in and opening an estate ourselves and proceeding with the administration in that way. And I say that because that's going to take a long time. So when we're administering the estate ourselves, that means we're filing the inventory, we're gathering assets, we're going through the whole estate administration process, and that obviously takes a lot more effort than your general collection file. So you really want to make sure typically that there's real property out there in the name of the decedent that's going to be gettable, or that you have a lot of secured collateral that you're going to want to basically make sure that you're in control of whatever happens next. Typically, what happens after you open that estate is the family will come in and step in as the administrator. But if that doesn't happen, you'd be on the hook to actually administer that estate in full. So that's why that cost effectiveness analysis is going to be really important there. So yeah, red flags as you kind of go through. You know, you may want to, you may be looking to try to move through this estate process on your own or just with your general collection staff. But I wanted to highlight some red flags and pitfalls that can really trip you up. And you know, I'm going to recommend that any of these things happen, you want to reach out to counsel and get us involved like this. So if you see that there's informal family possession, so like I said, somebody's car, you know, it may not be insured. The heirs are saying, oh, we'll keep paying on the obligation, we'll keep paying, it's no big deal, don't worry about it, there's not going to be an estate, all that stuff. You know, regardless of what they're saying, you're going to want to make sure that your interest to the collateral and your obligation are protected. So get the claim filed no matter what any of the heirs are saying. And then it's time to start going through the formal process of, one, verifying who has the collateral, and two, seeing how they want to proceed in a legally justifiable way. And obviously during that, you're going to want to maintain respectful and compliant communication, understanding that it's going to be a third party that you're largely dealing with. You're going to want to make sure that you have all of the authorizations for that person to be stepping into the shoes of the deceased party. So this is another issue that we see often. I'm dealing with a problem right now where a credit union sent out a repossession agent to secure a camper, and now the estate is alleging all kinds of improper activity related to that repossession. Unfortunately, we also don't have a copy of the agreement between the creditor and the repossession agent. So we don't have that language about indemnification and holding harmless and all that stuff, protecting the credit union from the counterclaim that we anticipate is going to be coming soon. So you want to always verify the estate status, and anytime you're going to need court approval, you need to go into the estate, or I'm sorry, to the probate court where the estate's filed, and get the probate judge on board with that. And I always mention this: the estate should, in theory, be there just as much for you as they are for the heirs. One of their main responsibilities is gathering and preserving assets. So if your secured collateral is part of the estate, part of their obligation is to gather and secure that asset. So if they're not doing that, it's time to make the judge in the probate case aware of that and ask for relief. Insolvent estates is the toughest thing that I deal with. Contested estates also similarly tricky. So when a estate is a responsible party and there's a rejection, or the estate saying that there's no money, it's time to dig a little deeper into that estate to see if you want to pursue the estate over the rejection. So you're going to want to focus on collateral recovery over unsecured claims. You're likely going to be a secured party, but if the secured collateral is the only asset that you're going to be entitled to, if there's nothing for unsecured claims, then you're going to be stuck at the value of what that collateral sells for. So while you're going through this process, you want to try to search for and verify as many assets of the estate as you can. And when you see that there may be a situation where an insolvent estate and you're going to be left with only the secured collateral, it may not be cost effective to litigate with that estate going forward. So yeah, just wanted to talk real quick about one scenario we had a little bit ago. The borrower passed away while repossession was being attempted. So we had the repossession going out looking for this vehicle, and in between, the owner passed away. So now we've got to bring that repossession agent back. We verified the estate, we filed the claim. We contacted that personal representative. I think it was actually our attorney. We had them verify all the insurance the issuances of the insurance and everything like that. We didn't have to start searching for assets because the estate wanted to assume the obligation for the car. So we had the verification of the insurance, we had the estate, we had an attorney who was checked in and actually interested in working with us. So we were comfortable in that situation to allow the collateral to remain out in the possession of the family as we lined up the assumption documents. So that's kind of a rosy scenario.
Yeah. I'm sure that doesn't always happen that way.
No, no. Most of the time we're dealing with individuals who are largely checked out, who are just looking to pull one over on their creditors, unfortunately. And similarly, in this next one, we had a borrower pass away after the repossession. And the family's coming in as the estate trying to redeem the vehicle. Now, there was an issue verifying whether or not there was an estate in this situation. My recollection now that I'm talking through this is the family came into the credit union attempting to redeem the vehicle prior to the estate being opened. And I think they just had a will, perhaps. I think that's what the issue was. And they were trying to do this all based on what the will said. So we had to make sure we're verifying everything with that estate, with those family members, that they're going to go through the correct process, while also staying mindful that we only have 6 months in Ohio from the date of death to actually finalize all of this, or we're going to be essentially out in the deficiency bounds. So we kept an eye on the clock as we were dealing with the family members, making sure that they're going to follow through with the promises that they're being made, that were being made. And that's staying in communication with the personal representative, making sure that they're providing adequate assurances at every stage. And if you're not comfortable in the situation, or you're not getting those adequate verifications, it's time to go and get that collateral. So just a real quick checklist. Whenever you have a decedent on an account, you want to verify that date of death, either through vendor searches or vendor scrubs, or if a personal representative has sent you notice of an estate. You want to always file a timely claim. No matter what, if I'm getting notification of an estate and I'm within the claim deadline, we're filing a claim immediately before we do anything else. So you want to document all the contact attempts, make sure you keep everybody in your organization and with the estate on the same page. You want to make sure you're not going forward with a repossession if you need court approval. So if you're not in a state that allows for self-help, or if you need to send additional notices to the estate as the new party, you want to keep cognizant of that and be mindful that the probate court is there for you too. So be sure to understand that you're able to take advantage of that when the estate is laying down on their obligations. And always keep cost effectiveness in mind. When you're dealing with estates, there's often not money. There's often heirs who are looking for a big payday potentially. But those are fewer and further between. So you want to make sure that you're spending your time and your effort on estates that are going to be worthwhile. So make sure you keep an eye out for inventories, accountings. You can pull credit reports with that obligation. Sometimes estates have to file to disclose certain assets that they have to be bonded. So use the public records that are at your disposal to try to verify as many assets as you can with the estate before you pour a bunch of money and effort into pursuing them.
And our key takeaways for today, Matt?
Yeah, so I'll hammer home this again. Early engagement is going to save you a lot of time. Once you have our office or your chosen counsel over these claims and able to kind of step them through the process, that's going to be the biggest help. So you want to spot key entry points, and once you're involved, you want to watch for red flags. and get any of those issues that are going to be potentially complex or potentially damaging to your interests over to counsel to review as soon as you can, because these probate deadlines are no joke.
Mm-hmm. All right, with that, if anyone has any final questions for today, please go ahead and drop them in the chat. One question we did just receive, Matt, is there a website we can check to see if an estate has been open before contacting an attorney?
So that's going to be jurisdiction specific. Not all jurisdictions are going to have online docket access. Unfortunately, Pennsylvania, where I primarily practice, very rarely has an available online docket. Ohio is a good one. A lot of times their dockets are available online. If you know the county where the person passed away, or you know the county where there is real property, those are likely the places where the estate's going to be opened. So you can check that county website. It's likely called Register of Wills. It might be called Orphans Court, or maybe just a probate division. Some division of that county court system may have something online where you can find that. Additionally, some jurisdictions require estates to advertise in a journal, in a legal journal, and a local paper of general circulation. And there are vendors where they essentially scrub those notices on a regular basis, and they may be able to identify when estates are open that way too.
Okay, okay. With
Yeah,
that,
so that's
there's
a big
contact information for everyone. Yep, thank you, Matt. With that ends today's presentation. Like I mentioned at the beginning, everyone will get a copy of this deck of slides today. Our contact information is included there as well. If you have any additional questions you'd like to ask, please stay tuned for details on episode 13 of Coffee with Casey that will take place in the new year. I can't believe it's going to be 2026 here soon, but this year has gone by so fast. As a reminder, please complete the survey that'll pop up on your screen. And we thank you very much for attending today. Thank you, Matt.
Thanks, everybody.